this is Marty coming from CHPTR, and today I'm gonna discuss about the chapter 3 with the title of Law on Obligations and Contracts. So according to the professional Don Skilly from the Colorado Technical University, it says that the ethical basis of business is integrity. Of course, it's integrity and ethical aspects that unites both private morality and public and professional ethics. So our learning objectives are: first is to identify the different kinds of obligations and contracts, and also to enumerate the ways of extinguishing an obligation, and also to enumerate possible and applications of contracts in the tourism law and travel and hospitality industry. So the law. So a person desiring to engage in a business in the tourism, travel and hospitality industry will meet certain obligations. So agreements arising from the category from the contracts will have to agreements arising from contracts will have to be made, and it also has the potential that breach from these agreements will be encountered. So therefore, there is a need to study the fundamental principles involving law on obligations and contracts. So the obligations, according to Article 1156, an obligation is judicial necessity to give, to do, or not to do. So that's the obligation of the being of the Article 56. So discussion of the law. So an obligation is a legal duty, however created, the violation of which may become the basis of an action of the law. So it is important to identify the presentation in a certain obligations. Once the presentation is identified, you can determine who the passive subject is, whom the active subject can demand fulfillment of the obligation. So here are some following obligations of the passive subject. We have the set, we have the A. So obligations to give a determinate things. So we have at least 4. So first is to deliver the things which he has obligated himself to give, and secondly, to take care of the things with proper diligence of a good father of the family, and thirdly is to deliver all its accessories and accessions, and lastly, to pay damages in case of breach of obligations. So we have number 2, obligations to do. So first is if the debtor fails to do what is obliged to do, it will be done at his expense. And secondly, if the work is done in contraventions of the tenor of the obligation, it will be redone at debtor's expense. And lastly, if the work is poorly done, it will be redone at debtor's expense. So the source of liability for damages of a party in an obligations are as follows. So first is a fraud. So we know that the fraud is in incidental fraud. So dolo incidente, so which is fraud incident to the performance of an obligation. So in fraud, there is an intent to evade the normal fulfillment of the obligation and to cause damage. So second is the negligence. So first we have the fraud. So and this time we have negligence. So the negligence referred here in the case of contracts such as common carrier is called by contractual the lack of diligence of carelessness. Negligence consists in the omissions of the diligence which is required by the nature of the obligations and corresponds with the circumstances of the persons or the time and of the place. So I guess that will be all about the report about chapter 3.